Hello and welcome. I'm Amritanshu Rai and you're watching Law of the Land on Rajya Sabha TV. Today we revisit the Supreme Court judgment on contract labour which settled the controversial issue of whether the contract labour can get automatic employment or not. We will also tell you about the 4-decade-old contract law. To discuss the issue, I have with me Mr. Dinesh Dwivedi, Senior Advocate, Ms. Ravi Birbal, Advocate, and Mr. Ashok Singh, National Vice President, INTUC. Now for the headlines. The Supreme Court settles the basic question in contract labour law, says that there can be no automatic employment. The Planning Commission favours review of contract labour as it does not provide social security. As the existing law does not talk about what happens to contract labour after he loses employment. Contract labour can't be automatically employed if the government notifies prohibition of contract labour in any enterprise. This judgment of the Constitution bench crashed the hopes of contract labour across the country, but settled the ambiguity in the law regulating contract labour. We try and revisit this judgment of the Supreme Court as it continues to be the law of the land.
Every government company is guided by the employment policy of the government, like providing equal opportunity and reservation for scheduled castes, scheduled tribes and other backward classes. In an event, automatic employment of contract labour was allowed. It could lead to violation of the constitutional scheme of reservation, as all contract labour would have been absorbed, first leaving little opportunities for the reserved category. But the Constitution bench of the Supreme Court prevented this by settling the issue.
The Supreme Court has held that the contract labour system cannot be abolished by the courts, maybe by the High Court, Supreme Court, Labour Court, Industrial Tribunal or any court. Reason being that the courts have to interpret the law, not to interfere in the employer-employee relations. That is a landmark judgment.
Let's look at the important issues that were settled by the Constitution bench of the Supreme Court. The judgment said that neither the contract labour law nor any other provision of any other law provides for automatic employment of contract labour. The Supreme Court ruled that its order was to be implemented in prospective and would not affect any arrangement which was there before the judgment came. The judgment also instructed the industrial adjudicator to be conscious that there is a genuine contract and not a camouflage to deprive workers of the benefits. The court also said that in the case the employer intends to employ regular workmen, then he may consider giving preference to the contract labour.
Laws are so rigid that the employers shudder to engage regular employees. They always prefer to have contract labour. Reason being that the contract labour does not have job security and the employer is benefited by engaging contract labour.
The Constitution bench judgment resolved the contradiction between two separate orders of the apex court. One order said automatic employment can't happen, while the other ruled in favour of automatic employment of contract labour. Worker strike of the Maruti Suzuki plant is one of the biggest examples for the exploitation of the contract labour. And despite of this, nothing substantive has been done till now for the welfare of the contract labour. With camera person Dinesh Rai, Aruna Thakur, Rajya Sabha TV.
The contract labour as of now is deprived of adequate wages, regular work hours and welfare benefits. As the principal law dealing with this issue, the Contract Labour Regulation and Abolition Act 1970 is underprotective. Now, sir, the point coming to you, is it deliberate as of now the way the economy stands and the way the growth in the economy is happening? Is it deliberate on the part of the government to allow employers a free hand in such matters? Or do you think it should be otherwise?
I think it's deliberate and there's nothing wrong to it. If you see the history of contract labor has always been there. The Contract Labour Abolition Act does not bring about the existence of contract labor. It in fact tries to control it and regulate it. That's the only object. So therefore, to believe that the contract labor would cease and vanish in thin air, that's not correct. Because fact is there are certain categories of employment which essentially require that kind of labor, like construction work, housekeeping, trolley pulling and pushing and so forth, so forth.
The
I mean, a large
unskilled.
number. So contract labor will always be there, has always been there. Even if you regularize all contract labor today, as of date, tomorrow there would be a fresh batch of contract laborers coming in. Because it is beneficial to the industry also, to some extent. They will like to employ contract labor because it is cheap labor. Plus the hassle of supervision and control also is less.
Right.
So it is cost effective for them. So it's there and it has been there always. The other thing which I wish to point out is this. The issue is not employment of contract labor as a result of abolition. Supreme Court has not said that. Supreme Court has said that their regular absorption as contract labor in the payroll of the company, that will not happen automatically.
Exactly. That's how we've also...
Not employment, because
Yes.
it says employment, which is not
No,
correct.
that is to simplify the entire term and not go the legal way. Ma'am, I'll bring you in.
Yes.
Is it deliberate to allow this to happen in the existing system? And do you think that is why the government is actually not touching this law?
See, contract labor, there is no prohibition in employment of the contract labor. And if we go through the act carefully, then virtually a contractor worker is given all the benefits and privileges that a regular worker has. He is given the equal wages, he is given all the other facilities that a regular worker is being given, all the records that are to be maintained for a regular worker are to be maintained for a contractor's worker also. Now the question comes as to why does an employer employ a contract worker and not a regular worker?
We are on the point, should we have the system the way it is, or do we need to tweak it, change it?
I think we have a perfect system. Only thing is that we need to have certain changes in the way they are being implemented, like the records, etc., that have to be maintained by the principal employers of the workers and of the contractors. They are to be maintained properly. Secondly, for everything, the managing director of the company is not to be made responsible, but the key person in the company, that is the person manager or the HR director, he should be made responsible.
Mr. Singh, I'll get you in. When the system is being liberalized, the economy is growing and more wealth is being created. In that situation, why do we actually need a system where the promoter or the entrepreneur is pinned down by various legislations and regulations which doesn't allow him to prosper and create more wealth to the country?
Sir, I want to say something in this context. That there are two important segments for the industry, labor and capital. Who they're investing capital, the industrialists, they're getting full response, respect and profit, everything. And the labor, the second important segment, is not getting the same thing as they should get it. Respect, proper remuneration, social security, benefits and all that. As Madam says, they are getting the equal remuneration as the regular employees they are getting. It's not like that. They are in the name of contract labor, it's 100% exploitation, nothing else. They are doing the same work as the regular workers on 1/3 salary in comparison to regular workers. That is the main problem actually.
So
all the trade union centers together in the country, major centers together, we went to the Prime Minister and say, fine, don't make him regular or permanent, but
Give him social security.
No, not social security. Not only social security. Social security, it is their right to get the social security. But so far the remuneration is concerned,
That should be improved.
yes, it's not so. It should be equal as the regular employees they are getting.
So the remuneration should be hiked, but
Yeah, it should be equal to.
Effectively-
the nature is the same. Nature of work is the same. Then this should get the same.
So what you're
remuneration.
saying is that the law as it has evolved as of now need not be changed, but it needs to be tweaked to get better
Sir,
remuneration.
law doesn't stop you to give remuneration actually.
Right. On that note, it's time for us to head into a break. When we come back, we will tell you about the existing contract law. Welcome back. Several agencies of the government are in favor of revisiting the 40-year-old contract labor regulation and abolition law. Even the Planning Commission has recommended the law needs a review. The existing law does not clarify what happens to the contract labor once he loses his employment. Let's look at some of the provisions of the existing law.
The economic environment of India has changed drastically in the last decade, giving rise to fears that the existing legal framework is against the contract labor and may lead to exploitation. It's keeping this argument in mind that the Planning Commission has recommended review of the law. The attempt is to ensure that the contract workers get the same wages, facilities and benefits as regular employees. So even if contract workers have no security of tenure, they would get better salaries with health cover and social security benefits.
What is most important is to have that clarity in the law itself, so that the possibility of interpreting it in different ways becomes very tight. You know, we lawyers love that interpretation part, because there's a whole thrill behind it. But I think if the law itself is not 100% clear, and if the law has not been amended to move with changing times, I certainly feel that there is a very strong requirement for change, for a relook at the entire Contract Labour Act.
The Contract Labour Regulation and Abolition Act was originally enacted to regulate the practice of contract labour and to avoid exploitation. The law also empowers the government to prohibit employment of contract labour in any establishment hosting the restroom, drinking water, latrines and urinals, washing facilities and first aid facilities.
The skill integral is, that put in as in the component of his, wages. Then and social security is paid to him, and he is hired from the contract labor board. I think the chances of exploitation will get minimized.
According to the constitutional scheme of things, labour issues fall both in the purview of the state and the central government, which allows both the governments to make laws in such matters. As of now, there are about 44 separate labour laws existing simultaneously in the country, due to which the courts have a problem in interpreting them. Contract labour is a wide area which comprises of skilled, semi-skilled and unskilled jobs. But today's irony is that contract labour is more exploited in core sectors. With camera person Dinesh, Aruna Thakur, Rajya Sabha TV.
What are the big gaps in this law? Can we say certain issues need to be defined categorically to make it more contract labour friendly? Well, my question to you, Mr. Singh, is what Mr. Pant said, how would you react to that?
Sir, Mr. Pence already accepted it's minimized. He can't dare to say he finished now. Not minimized actually, it's going on. Exploitation is going on in the name of contract labor. I only want, he's my actually good friend. We used to sit together in some meeting actually.
Right.
And we share each other's views. As you say, they minimize, try to
and
minimize.
you're not in favor of minimizing. You want
why
to
minimize?
You want to equalize.
It's enough now.
Enough.
Labor contract has been 1970, 40 years has been already passed. There are so many amendments for the who they're investing capital. So many amendments
Changes
have been taken
made.
place. Why not investment in other parts? With the labor investment, there is no amendment.
Right.
Why?
On the point of codification, it was very clearly made out. One of the lawyers said that it should be written in black and white, so that it is not subject to interpretation and there is no confusion for the courts to interpret it that way. Do you think that will help, and that is what should happen?
Yes, that is very important. See, the Act very clearly says that a contractor worker doing an equivalent work to a regular worker has to be paid equally. Now, there are two problems that what we face in court when this problem comes is that who would be paying the equal wages? Is it the contractor or is the principal employer? And secondly, what is equality? Is it the eligibility? Is it the seniority, the years of service, the qualifications, or is it the selection process? So we need to define two things very clearly: who would be responsible, the principal employer or the contractor, and as to what is equality. Equality, is it only in terms of the process of work, the work being done, or equality also in terms of who the worker is and how can he be compared to a regular worker?
And all this needs to be clarified for a better implementation.
If this can be done, then we can certainly get some good changes.
Okay, this contract labor law talks essentially of where there is a contractor involved. What happens where the employer directly takes on contract labor in that situation?
No, that is a case of a labor supply, as we call it. He can't take on directly. He'll always employ a contractor who will supply
but
labor.
in a situation, if it's defined as a government and the government takes on direct contract labor,
They do. Most of the government of
what
India
happens in that
undertakings-
situation?
See, the situation is, you see, like this.
They don't do.
Wherever this kind of thing happens, that a contract labor is being unduly employed in place of regular workmen, so the process is that an industrial dispute is raised by the workman for adjudication of the labor court. And the labor court gives a declaration based on certain principles, three, four principles, on which they determine whether this is a sham or a camouflage to evade labor laws. Then in that event, they recommend that this is a sham transaction and consequently it should
Action
be
will be
abolished.
taken. On the remuneration part, equalizing remuneration, what needs to be done with the existing law so that at least on the remuneration front?
Quite right. See, my friend is right when he says the bane of contract labor is wages. Not only unequal wages, but untimely payment of wages too. The contractors do exploit, so do the companies. And that is the major reason for employment of contract labor. It's cheaper. Now, what I suggest is, as they are saying, that the law should be tweaked in the sense that there should be a clear-cut provision providing that they will be paid the same wages as the regular employee in the company doing the same work. It has to be tweaked in that sense, so that if it is found that the contractor's workman is doing the same work as a regular workman would be doing, then he'll get the same wages.
And allow the law to be silent on automatic absorption?
That cannot happen. As I say, it's a myth. To expect that the contract labor system would vanish or cease one day, it's a myth. In a growing economy, industries are coming in every day. There are certain segments which will require contract labor, as I said. Consequently, we really can't wish it away.
Mr. Singh, do you think automatic absorption, the way it has been interpreted and says that contract labor law actually doesn't allow this to happen in a situation where contract labor is prohibited and a notification is made to that effect by the government. In a situation like this, do you think the way it has been interpreted, that is how it should continue, or there needs to be a change?
Sir, I want to say something actually. You say, the government, in any central government, state government, central public sector, state public sector, they cannot employ the contract labor directly. And they have to go through some supplier, the contractors. And they are giving, say, I want to cite some example because I'm the president of the Indian National Defence Worker Federation also. There are 41 ordnance factories in the country. And in one factory, the total, I think there are 35 to 40,000 workers in the contracts. They are working throughout the country in defense sector, in ordnance factory sectors, in the defense public sector, another 50,000. Say 1 lakh total. And as per law, central government public sector, they should get 180 plus 90 workers. And they, in addition to that, contractors, they are getting service charges. In addition to that, from the government, from the public sector again. I want to say only, I want to request, if the employer can send the, as my Honorable Trivedi said, suggested, if they get their remuneration through check in their banks, exactly 180 plus 90 per then certainly there should no here and there
on this issue.
And social security also. Right. They must maintain EPF, ESI, other benefits, and it should cut, it should go to in their accounts so that they can all these social security also in the same time. And third, sir, there are three harassment. Workers in working hours, they work more. Financially harassment, working hours harassment, and mentally harassment, and social security harassment.
All this should be codified according to you.
Yes, sir.
Clearly. It's time for us to head into a break. When we come back, we will show you an interview with Mr. R. Mittal, Secretary, Hind Mazdoor Sabha. Welcome back. My colleague Aruna Thakur spoke to Secretary Hind Mazdoor Sabha R. Mittal and tried to get his point of view.
There are two landmark judgments of the Supreme Court, but both are contradictory to each other. One favors the contract labor, but another doesn't. So what is your opinion on these judgments?
Whatever was said by the Supreme Court in the earlier judgment was that they should be regularized just on completion of either some period or after abolition of the contract, immediately after the work. In the second judgment, what they have said, it is not automatic. Regularization is not automatic. They say regularization should be there, but there should be subject to availability of vacancies. So that is the basic difference between the two judgments. So I don't say these are exactly contradictory, but it is just dilution of the earlier instructions or judgment.
Contract labor is a very wide area. So tell us that where more exploitation of contract labor is going on.
This contract work was agreed, practically it is agreed by the trade unions also now. It was only on one demand of the employer that they should be given flexibility in employment. Now the purpose of flexibility was that not in the perennial nature of work, but in otherwise some work which is not perennial, they should be given that flexibility subject to the conditions that their wages and their working conditions will not be compromised. It was not to reduce the cost. It was for the purpose of just giving them flexibility. Now they have made it a practically applicable everywhere. For every work they are employing contract labor, which is bad in law.
Recently, Planning Commission also suggested that there is an urgent need for the amendment in the contract labor. So tell us your opinion on this.
In the 43rd session of the ILC, Labour Minister made a statement at the conclusion of the Indian Labour Conference that he was highly disappointed at the attitude of the employers, because he said, I was very sure that with this conclusion we will be able to get the consent of the employer friends, at least on the contract labor business. But nothing could be done. Now they assure us that they are doing something, but to me there is no political will of the government to do it. And the moment the political will is developed, it is not difficult to implement this law.
The Planning Commission in its 12th five-year plan stressed that an All India Service for Labour Administration be set up to provide professional expertise in labour administration, autonomous bodies and labour adjudication. But the point that we would like to, it's largely, the core area is insecurity. What needs to be done to actually ensure that there is an element of security, even if the contract labour is working? Because obviously you can't give him complete security the way you give an employee. But what are the basic things that can be given to him without upsetting the employer's apple cart and also allowing him certain amount of security?
No, as my friend suggested on the earlier occasion, that give him the benefit, equal benefit of wages, EPF and ECIS facility.
Is it difficult?
ESIS
is it difficult for the government to do that?
No, not at all. They just have to provide one of the, in the regulations, they have to provide one of the conditions,
right,
for grant of license or grant of registration in the for the employer and the contractor.
Okay.
And if that condition is prescribed at the pain of penalty, then automatically, you see, you give every benefit to the contract labor, make him equal to the regular workman. No one is going to employ a contract labor. That's the easiest way to finish off the.
Does the existing law address the issue of security?
It does. If we go through the Contract Labour Act Regulation Abolition 1970, then one of the conditions for grant of license to the contractor is that there would be equal pay for equal work. which means that if he is working and if he is doing the work that is equally as good as principal employer's regular worker, if he is spending equivalent amount of time, then he has to be given equivalent wages. As far as Provident Fund and ESI are concerned, although they are not mentioned in the Contract Labour Act, but if we go through the Employees Provident Fund Miscellaneous Provisions Act 1952 and the Employees State Insurance Act, they very clearly say that a contractor's workers' Provident Fund and ESI would be the ultimate responsibility of the principal employer. So, like I have been stressing upon,
but then there is a dichotomy. The principal employer can't take it on under this law, na?
Yes.
Under the
yes, but he can always go under the PF Act.
But then the will is not there.
Well, see, the point is we already have very good laws. What is important is we need to implement them. The implementation is the difficult part.
Okay. Now, Mr. Singh, last word on this. Last word should be yours. Last word on this. What should be done to ensure security, at least?
Sir, as you say, na, ki will require a will. Actually, there is a one phrase is very common and very popular. There is a will, there is a way. Here there is a way, but there is not a will actually.
On that
there is a way, there is a will. Will is not there. I want to request ki now the will, as Madam say, ki principal employer. The principal sole responsibility goes to the principal employer actually, not the contractor. It is the duty of the principal employer to give to provide them wages, security and everything.
Right. On that note, thank you, sir, and thank you, ma'am, for joining us on this discussion. It's time for us to end the show. You can email your suggestions and comments to law.rstv@gmail.com. You can also watch our shows on the YouTube. We'll be back with a new issue and a new episode. Keep watching Rajya Sabha TV.